this Committee on Civil Law and Data Practices Policy Committee to order. Today is Thursday, March 31st, 2022. This is our final hearing before our second deadline. We have an overflowing agenda, which keeps overflowing on us. Members, you got an email about it, but Senate File 4209 got added to the agenda. It will be at the end of the agenda this evening. We're going to go as far through the list as we can. I'm guessing about 5 bills or so in this afternoon segment. Then we'll be recessing till 5:30 to pick up the balance of the agenda. So we'll get started with Senator Rosen and Senate File 4025. Senator Bigham.
Thank you, Mr. Chair, about the schedule. Will that be obviously dependent on if we get called back to the floor today? Because we're in recess.
Yes, so we will have to work around the floor schedule too. And I'm assuming we're back in this room when we come back this evening, but we'll verify that. Senator Rosen, you're batting leadoff today. Welcome to the committee.
Thank you so much, Mr. Chair and members, for allowing this hearing on Senate File 4025, which is the opioid settlement bill. And we are in front of you because of Section 1, the claims section. But just to give you a little brief summary and tee this up so you understand where we're at, is on July 21st of 2021, last year, a $26 billion offer to settle was made by opioid manufacturer Johnson & Johnson to the tune of $5 billion. And the big three distributors, McKesson, AmerisourceBergen, Cardinal Health, for $21 billion to resolve their liabilities in over 3,000 opioid-related lawsuits nationwide. And this last November, McKinsey settled for nearly $600 million with 49 states over their role in the opioid crisis and their sales advice to drug makers, including Purdue Pharma. And before I go through Senate File 4025 and Section 1, just a little bit of background, Mr. Chair and members, on the 2019 opioid legislation that was passed, House File 400. It was a landmark piece of legislation that created licensing and a registration fee increase on opioid manufacturers to fund the Opioid Epidemic Response Fund. At the time, in 2019, we negotiated a 50-50 split, 50% to the counties and tribes for out-of-home placement costs due to drug-related abuse cases using data from the previous calendar year. The remaining 50% went to ORAC, which is the Opioid Epidemic Response Advisory Council. Senator Eaton and Senator Coran have sat on that council. At the time, when we settled this bill in 2019, we knew of the lawsuits and the potential litigation, but we were definitely uncertain of the mechanics. The state is now projected to date to receive over $300 million. So the state, 87 counties, 140 Minnesota cities, all filed lawsuits. Senate File 4025 is necessary to reflect the technical changes required from the 2019 legislation in order to capture the settlement funds. Last summer, the state signed on to the National Opioid Epidemic Settlement, and over the course of 4 months, the AG's office carefully negotiated between the state and the local governments to reach a comprehensive agreement for allocation of Minnesota opioid funds. All 87 counties and 140 cities joined this agreement. But as part of the multi-state national settlement, the companies want current lawsuits resolved and want to prevent future lawsuits. So in order to guarantee Minnesota receives all entitled funds without delay, a statutory claims bar is needed to release any remaining claims and prevent future claims, and that is why we are before you, Mr. Chair. With me to further explain this in better detail is Mr. Eric Maloney, Assistant Attorney General, and Julie Ring, the Executive Director for Association of Minnesota Counties, is, I believe, on virtual.
All right, thank you, Senator Rosen. Mr. Maloney, welcome to the committee. If you'd identify yourself for the record and then begin your testimony.
Thank you, Chair Matthews. My name is Eric Maloney. I'm an Assistant Attorney General with the AG's office. Good afternoon, Chair Matthews and members of the committee. My name is Eric Maloney, and I'm one of the Assistant Attorneys General that was assigned to opioid investigations and litigation a long time ago, back in 2016, under the former Attorney General Lori Swanson. Thank you for the opportunity to be here today and I want to give a big thanks to Senator Rosen and the other bill authors for their incredible work and leadership on this issue. So as Senator Rosen mentioned, last summer, the state of Minnesota joined nationwide settlements with 4 companies, 3 opioid distributors, McKesson, Cardinal Health, and AmerisourceBergen, and opioid maker Johnson and Johnson. These settlements are the culmination of years-long multi-state investigations into these companies stemming from their actions that fueled the opioid crisis. In addition to prohibiting misconduct by these companies in the future, the settlements provide for potentially more than $300 million to flow into the state of Minnesota. Now, these settlements are unique. They resolve the claims not only of states, but also of thousands of participating cities and counties nationwide. The financial structures of the settlements are designed so that as more cities and counties join the settlements, more money is received by the state. This is meant to incentivize cities and counties to join and incentivize states to encourage them to join. The settlements also have a special structure that allows individual states to create their own agreement with local governments to set up how funds should be allocated and spent within the state. So what we did here in Minnesota is work with a kind of large cross-section of stakeholders. We had the Association of Minnesota Counties, League of Minnesota Cities, Coalition of Greater Minnesota Cities, numerous state agencies, including the Minnesota Indian Affairs Council, MDH, DHS, MMB, some legislative members, state and local public health officials, and healthcare providers. And after it was 4 to 5 months of meetings that was facilitated by the state's Office of Collaboration and Dispute Resolution, we were able to construct an agreement between the state and local governments, the crux of which provided that 75% of the settlement funds would go directly to cities and counties, and then 25% going to the states to be overseen and then spent by ORAC, by the Opioid Council. The agreement also includes a 13-page non-exclusive list of approved programs and strategies that the state and cities and counties could use for funding to fight the opioid crisis. We had all 87 counties and more than 140 cities sign on to this agreement, the state-local agreement once it was done, and join these settlements by January 2022, which for Minnesota was a huge step towards maximizing the amount of settlement funds that we would receive. This bill, Senate File 4025, is the necessary next step to implement the state-local agreement and build upon the HF 400 framework from 2014. There are 3 main items that we're looking at to kind of have this next step and put a capstone on these settlements. First, Senate File 4025 enacts a claims bar which ensures that Minnesota will receive maximum payments from the settlements. This claims bar would quiet the claims of one outlier litigating local government and would also quiet the claims of kind of all future unknown claims, which would let Minnesota lock in payments. It guarantees that there's no risk of those payments being reduced or delayed, and would save the state millions of dollars if ongoing claims were allowed to continue. Second, Senate File 4025 amends the statute to enable the agreed-upon 75-25 state and local split. And third, Senate File 4025 unlocks settlement funds, which are currently kept in a separate account until 2024, or if a certain threshold is met. It takes those funds and lets them be used right away, so that city, counties, and the state can start fighting this crisis as soon as possible. So with that, I thank the chair and members, and happy to stand for any questions.
Thank you, Mr. Maloney. Next, Julie Ring, I believe you're on the Zoom call.
I am. Thank you, Mr. Chair. I hope you're able to hear me okay.
I can hear you. I don't see you quite yet, but we'll
Okay.
highlight your window. There you are.
There we
Welcome
go.
to the committee. If you would identify yourself for the record, and then feel free to begin.
Thank you, Mr. Chair. My name is Julie Ring. I am the Executive Director of the Association of Minnesota Counties. I wish I was there in person with you today, but instead of being in my office a block from the Senate building, I'm up in central Minnesota meeting with commissioners in Crow Wing County today. So thank you for allowing me to join. And given the shakiness of Wi-Fi and your schedule, I will be brief and simply thank Senator Rosen for bringing forward this important legislation that allows us to modify Minnesota law to match the MOU that was agreed to by cities, counties, and the state. Mr. Maloney has provided a great overview of the process we went through over the course of several months last fall. Counties, cities were actively engaged in multiple meetings every week as we hashed out the details of the distribution of funds and uses of funds that are outlined in our memorandum of agreement. This bill would allow us to move forward with that agreement. Importantly, I think all 87 counties, in addition to signing on to the memorandum of agreement, also urge the passage of this bill. We don't very often get resolutions from all 87 counties, but in this case, we do have resolutions of support for this bill and the provision that's in front of this committee today. And so I will pause there and just tell you that we are hopeful that this bill will pass quickly so that we can get this money out to do the good we know is necessary. And I'm happy to answer any questions or provide additional information if it's useful.
Thank you, Ms. Ring. Senator Rosen.
Thank you, Mr. Chair. We do have the A3 amendment that will get the bill in the shape necessary.
Thank you for reminding me.
Mr. Chair, I'll move the A3 amendment.
Senator Bigham moves the A3 amendment. Senator Rosen, would you describe the amendment?
Actually, Mr. Chair, this came from, I
Council.
believe, the Association of Minnesota Counties as comfort language that would apply to the lawsuits against the 4 companies involved in the settlements, the 3 distributors and Johnson & Johnson, and to make clear that this bar is for only those 4 entities. If I said that wrong, Ms. Ring can fill it in, or Mr. Maloney, but basically it's clarifying language.
Either of you wish to chime in on the amendment?
Mr. Chair,
Ms. Ring.
I will, thank you, Mr. Chair. Julie Ring again, and I will just simply say, since we did bring this forward, we did work with the AG's office and Senator Rosen, I think this is a simple technical change, really is comfort language to be crystal clear about how this bar affects these lawsuits specifically. So we appreciate Senator Rosen's support and the committee's consideration of the amendment.
Thank you. Mr. Maloney.
Thank you, Chair Matthews. Nothing further to add. We did work with the Association of Minnesota Counties on this language and completely agree with what's been said, that it is comfort language and just a technical change to clarify some of the language in the claims bar section.
Any discussion to the A3 amendment? Seeing none, all those in favor of the amendment, say. Okay, all those in favor of the amendment, say aye. Aye. Opposed, no. The A3 amendment is adopted. All right, now to the bill as amended. Anything further, Senator Rosen, or should we go to questions?
No, thank you. It just, that amendment, we are trying to move succinctly through the House and the Senate because of the timeline on this bill. We are expecting to get this first settlement payment in April.
Correct.
And so trying to make sure that we are succinct in it.
All right, thank you. Any discussion from committee members? Any discussion? Seeing none.
Mr. Chair,
Senator Bigham,
going to finance?
it's going to finance.
Mr. Chair, I would move that Senate File 4025 as amended be recommended to pass and sent to the Committee of Finance.
On that motion, members, all in favor say aye.
Aye.
Opposed, no. Motion prevails and the bill is passed. Thank you, Senator Rosen.
Thank you very much, Mr. Chair, Senator Bigham, and members.
All right, next, Senator Ruud, Senate File 2768. Welcome to the committee, Senator Ruud.
Thank you, Mr. Chair. Today before us, we have Senate File 2768. It is the SALT Applicators Voluntary Certification Program. And Mr. Chair, I know we are short on time, and so I'll just let my testifiers speak to the bill. I think there's only one section that you need to look at.
Ms. Primo, could you orient us on the section for this jurisdiction?
Mr. Chair and members, there's also a brief summary in your packets that provides a summary of just the piece in our jurisdiction, and that begins at line 2.13 and through line 2.30, and it addresses some liability of the various parties.
All right, thank you. So there is Mr. Klemps, I hope I'm pronouncing that right, Sue Neeson, and then Joel Carlson are the three testifiers for this bill. So, Mr. Klemps, we'll start with you. Welcome to the committee. If you'd identify yourself for the record, and then please begin.
Thank you, Chair Matthews, and thank you, Senator Ruud, for your proactive approach to curbing the increasing problem of salt pollution in Minnesota water bodies through SF 2768. My name is Aaron Clems. I am the Chief Strategy Officer at the Minnesota Center for Environmental Advocacy, a nonprofit organization with almost 50 years of experience using law and science to defend Minnesota's environment. MCA supports this bill, SF 2768, which takes a modest yet significant step toward addressing this environmental problem in a non-regulatory manner. New Hampshire passed similar legislation regarding liability for salt applicators in 2013. While there are differences between this bill and the law in New Hampshire, they share a number of key features: the adoption of best management practices, a certification program, and reporting requirements, and language that addresses civil liability for applicators who are certified and follow these best practices. State and local governments are already taking steps to reduce their salt use while protecting public safety. This bill addresses private applicators, which represent about 25% of the salt used statewide, and with whom we need a different approach. Section 3 of this bill provides a limited liability waiver for certified applicators who follow best management practices. The precise wording of this section is challenging, since the reality is that hardly any case involving slip and fall injuries goes to trial. Nearly all are addressed outside of the legal system or are settled out of court. One important aspect of this legislation as it pertains to liability is the establishment of best management practices in statute and a route to be certified as following them, since that will be a strong and useful defense against a liability claim. I'm aware of concerns from applicators, including the letter that's in your packet today, that the current language in Section 3 is not as strong as they would like it to be. But this is a good bill that provides a clear signal about what the best practices are for salt application in Minnesota. It will have benefits for everybody. As with any statute that affects liability, it will probably take some time to fully assess the impact of this law if it becomes a law. But the goal here is to give a clear signal that applying less salt in ways that maximize its effectiveness is the right approach. Otherwise, we will continue to see piles of salt on the sidewalk used as a symbol of action and effort, even when it just pollutes our water and does not protect us and make us any safer. In closing, I'd like to remind everyone that de-icing salt is widely overused and over-applied in Minnesota. The permanent impact of this overuse is a problem that must be addressed now. And I encourage everyone to consider smarter salting practices and training, and to address this issue in part by moving this bill forward. And I answer any questions you might have.
Thank you, Mr. Klemps. Next will be Sue Neeson. Correct my pronunciation if that's needed. Please identify yourself for the record, and then please begin.
Chair Matthews and members of the committee, I want to thank Senator Ruud. This is important legislation. My name is Sue Nissen, and I'm a Minnesota water steward, and I'm a volunteer with the citizen group Stop Oversalting. And we are here in support of Senate File 2768 because it's good for clean water, it's good for our state's infrastructure, it's good for our commercial salt applicators, and for maintaining public safety using less de-icers. And here's why. This spoon and this pail demonstrate the pollution power of just a small amount of de-icer. Just 1 teaspoon of de-icing salts will dissolve in 5 gallons. This is a Home Depot 5-gallon bucket. If I fill it with water and put 1 teaspoon of de-icing salts, this water is permanently polluted to the EPA standard for impairment. So just a little bit does a lot of damage. Removal of dissolved de-icers is prohibitively expensive, and it's impractical. So de-icing salts are accumulating in our waters, and the result is our fresh waters are becoming saltier and saltier every year. And we don't see that accumulation because dissolved in water, it's clear. But the data is in on our salty water, 50 water bodies above the EPA impairment for the standard, 75 more water bodies close to being impaired, upward salt trends in our drinking water monitoring wells, and in our groundwater. In Minnesota, we use about 400,000 tons of de-icer every year, and that is a lot of teaspoons full of de-icer. Stopover salting volunteers frequently talk with commercial applicators and the property managers that hire them. Many are not trained, we find, in their best practices, and overwhelmingly there is pressure to oversalt because visible salt on pavement and in parking lots is to believe to provide protection from slip and fall lawsuits. The combination is driving over application. And we find that most applicators that we talk to are acutely aware of the destructive side effects of the de-icers. They love their lakes. In general, this is a group that loves to fish, and they are concerned about salty water and fish going forward. And they have untold amounts of frustration over wasteful infrastructure damage and replacing dead landscaping year after year after year. However, at the end of the day, the applicators need to protect their small businesses, and currently over-application of de-icers does just that. So the opportunity for this liability protection is an incentive for commercial applicators to enroll in MPCA's highly effective Smart Salt training. It's a voluntary program and certification, and it teaches science-based best practices. We at Smart Oversalting, we attend the trainings too, and we see these applicators return to their companies with great enthusiasm for reducing de-icers because they know then that they can do so, reduce and maintain public safety, and that's really important. They report 40 to 60% reductions in their salt use after their first year of training. At Stop Oversalting, we have a vision for Minnesota that every teaspoon of de-icer counts in a positive way, and this bill is a real and necessary step in that direction. Please support 2768. And Mr. Chair, I have spoons. Chair Lermer, I have spoons for the senators on the committee, if somebody could pass them out.
We'll direct staff to direct your spoons.
Awesome, thank you very much.
The next person giving testimony is Sue Nissen.
That's me.
Oh, Joel Carlson.
Joel Carlson, Mr. Chair.
Welcome to the committee. Would you identify yourself and
Thank you.
proceed?
Thank you, Mr. Chairman and members. I'm Joel Carlson. I'm here on behalf of the Minnesota Association for Justice, and we too are in support of this legislation as it's written. We acknowledge and support the idea of keeping chlorine out of our waters, and the appropriate use of de-icers is critical to that mission. And I can tell you from personal experience, because like Senator Ruud, I'm a certified salt applicator. I've taken the training, I understand what it is, and I believe that this is an appropriate bill for us to move forward in Minnesota. But much like the education we need to have about salt and de-icers, I think just a little bit of education about liability cases in Minnesota and Section 3 of this bill is also, I think, warranted. The fear about litigation in Minnesota, while I appreciate it, is probably as overused as the salt that we have on our sidewalks. Cases in Minnesota are down over 55% in the last 2 decades. And there were, in 2028 cases, complete injury cases. That's all that were filed for our 5.7 million citizens in 2021. And to put that in perspective, there are about 7,050 commercial contract cases filed in court during that same time period. And while we respect and want to have businesses have their chance to have their day in court, we think consumers should have that opportunity as well, and we think this bill provides that, and I'll tell you why. What it says on lines 2.3 to 2.6 is that an applicator that takes this class and uses best practices would not have liability for a subsequent injury if they follow the best practices, they do the record keeping, they do what they're trained to do. If they do that, excuse me, they wouldn't have liability unless they didn't follow best practices and they knew of a dangerous condition and didn't do anything about it, or they were negligent in their obligations to the property owner. These are the general rules that we follow today. But having taken the training and know that there's a provision in there about liability, we think putting the rules of the road in that training makes sense, and that's why we support having it in this bill. We hope in turn, after they do the training, that they'll use less product. And I want you to know that we are not treating these applicators any different than anyone else in Minnesota. Nowhere in law do we provide a greater protection of negligence in statute. And we don't do it for municipalities. We don't do it for ag tourism. We don't do it for livestock operations, all of which have liability protections that are based on negligence. And there is a letter in your file from the landscapers that would like to see that tougher, and they'd like to see a gross negligence standard. And I just want you to know what gross negligence is. Gross negligence is the equivalent of no care at all, not even a slight bit of care. It's an indifference to your legal duty and a very high degree of carelessness. That is not the standard that we want, and it's certainly not what we want to train salt applicators, that once you take this test, your duty now is gross negligence, and that you have no duty any longer. That's not what we want for training. So we support the bill the way it's written. We've been working on this a long time. We'd love to see it get across the goal line, and moving the liability standard, which we don't even do for government in chapter 46603, subdivision 6. Their standard is based on negligence, just like this bill. We support it the way it's written, and we hope that you'll advance it along and pass this across the goal line. Thank you, Mr. Chair, and we're happy to answer questions.
Thank you, Mr. Carlson. We don't have any other testifiers. Is there anyone in the audience who wishes to speak for or against this bill? Senator Johnson?
Just a quick question for Mr. Carlson. Mr.
Go
Chair,
ahead.
Mr. Carlson, just quickly, just for reference sake, so you said that the lawsuits were going down over the last 20 years based on this sort of activity. Has there been any increase, correlating increase on out-of-court settlements based on that you're aware of? Or is it just generally these sorts of incidents have been going down regardless if it's a case or if it's out-of-court settlement?
And
Mr. Carlson?
thank you, Mr. Chairman and Senator Johnson. The 2028 cases I referenced are all injury cases in Minnesota. Very few of them are related to this activity. That's the entire field of personal injury cases in Minnesota, and they have been declining. Is some of that related to mandatory arbitration? Possibly. But we have seen a decline in cases, and I know when Chief Justice Gilday was in talking to Senator Limmer's committee, she talked about the few civil cases that are coming forward in the state, and so they are going down dramatically, and I don't think immeasurably pushed off into arbitration or anything else. And I think it's also important to note, Senator, that about 4 years ago, the courts changed the filing requirements in Minnesota. So you used to be able to file a case and try and resolve it and not put it into court, pocket filing. They've eliminated that now, so you have to put that case in court after a year. And so, we think the numbers are very reflective of what's really happening in litigation in Minnesota.
Senator Westrom?
Thank you, Mr. Chair, and Mr. Carlson. Just maybe you can touch on how are we gonna establish if best management practices were followed or not, and maybe step back one from there. Do we know that best management practice yet, or is that gonna be ever-changing by the commissioner of MPCA? How are we gonna know them, and then how are we gonna know if they were followed or not? It seems to me that the liability waiver either doesn't really mean anything, or it's gonna just change a little bit of what's fought about. Can you explain that a little bit more? I'm not sure I'm clear on it yet.
Mr. Carlson.
Absolutely. Mr. Chairman and Senator Westrom, thank you for asking that question, because the program right now is in place. It is a voluntary certification program, and it does go through what best practices are, as we know them today, about temperature of the ground when you're applying the salt, about how much salt to apply to any given area, and when you need salt and when you don't. And it goes through what the best management practices are. And in the bill on page 2, on line 2.31, it talks about record keeping, and it teaches you how to maintain records about when you put the salt down, how much you put down, so that it's a very conscious exercise to know how you're utilizing this material that can be harmful to the environment. Do we think that we'll develop better practices in the future? I think we will. We already know right now that liquid chloride is better as a treatment than granular. And many times you can use sand instead of, for tackiness, instead of a de-icer. So best management practices will evolve, and the training will evolve with it. But this gives rules of the road for people that do take the test, that do want to reduce the amount of salt that they use on their properties.
And Mr. Chair, Mr. Carlson, you said this program already does exist? This bill is not creating any new voluntary program, or maybe Senator Ruud, you can touch on that as well. Can you clarify that?
Senator Ruud.
Mr. Chair and Senator Westrom, we have already started this program because it's in Crow Wing County, my own county. We think it's such a important piece that we now train all of our snowplow drivers in salt application, because the county figured out that they would save an immense amount of money by only applying when they needed to, based on the temperature and all the other things that the snow plow drivers have in their vehicle. So the Crow Wing County, they train their snowplow officers or drivers every fall in this. And so there is a certification program that has been put together, that's been updated. And right now, we did that on a grant that we were able to apply for. And so this bill actually allows that program to exist. There is a, let's see, what line is it on?
And Mr. Chair, Senator Ruud, that's through the MPCA
Western.
now, or is that through your county that this is?
No, that's through the
Senator
MPCA,
Ruud.
Senator. Excuse me, Mr. Chair.
And
Senator
so,
Westrom.
so,
Senator
Mr. Chair, Senator Ruud, who does this expand it to? And then the liability protection, maybe you or Mr. Carlson can talk to. The liability protection is something new, expanded to who, and who's the bill expanding to as well?
Well, Mr. Chair and Senator Westrom, we feel that there's a lot of folks out there, like in Breezy Point, we have 8,000 timeshare units, and so they all are shoveled and salted, and so that's a commercial application, and they would be able to, well, they would be able to take this test and be certified. That would certainly help Pelican Lake. There's all sorts of apartment buildings, that's kind of where we're aiming at, those commercial applicators that use salt all the time. I don't think you can walk into a building now where you don't see a 5-gallon bucket full of salt and a scoop for salting sidewalks, and we kind of would like to have them have training so that better use of salt. And I don't think that we're adding any different liability to this bill other than what's already in law. We're just putting it in the bill so that they know what it is. But we are not changing any liability for anyone. They already have this protection, but we feel it as part of the bill, it really lets them know what the rules of the road are.
So,
Senator
Mr. Chair, I'm not exactly clear, Senator Ruud. Who are we expanding the bill to then if this program already exists? And if we're not expanding it to any liability, I'm not sure why we have the bill here at all. It seems like we've got to be expanding it to somebody.
Mr. Carlson.
Mr. Chairman and Senator Westrom, that's an excellent point. And if you look at who this is now going to apply to, which it does not apply to today, on lines 1.10, we define a certified commercial applicator. And that is someone who has taken this training and has been certified by the MPCA through this program. And then if you look at the liability section on 2.23, that provision to use this as a defense is going to apply now to certified commercial applicators. And so that does not exist in law right now. That is what we are changing. So if you take the test, you would be able to use this protection in this bill, and it would become a defense for you. And it also says, Senator Westrom, on the liability section on 2.29, it also says that if you don't have this training, you can't use this as any type of defense.
So,
Senator Westrom.
So, Mr. Chair, and thank you, Senator Ruud, thank you, Senator Carlson, or Mr. Carlson, that helps. I'm still a little uncertain of where this will start and where it stops. So for instance, the bucket of salt or treatment outside of in the foyer of a building or apartment, if we take that away, I mean, a lot of times it's so if somebody's up early, they can salt the sidewalk or sand it so other people coming and maybe the commercial person or the caretaker or whoever's doing it otherwise can't be everywhere at once. But if we start taking that away, it seems like we're following best management practices, but might defy common sense that the first 2-3 hours of the sidewalk being slick ice doesn't get anything put on it, and now everybody leaving for work before that so-called certified person comes. But if they have the bucket there, they'd be defying the best management practices and not have the liability. So I'm just not sure this is, do we really need to go down the road of having government decide best management practices? I think we've seen in the last 2 years that government doesn't always get it right when you look in hindsight. And so I hate using that as the standard to decide if somebody can sue or not, because there might have been a better way for the owner of the building to handle it. And now we're saying you can't sue somebody for damages that they were negligent for. I guess, can you correct me where I'm missing a point or something here, Mr. Carlson, if
Mr. Carlson.
you can.
Thank you, Senator Westrom, and just a couple of points. We're not, this bill doesn't eliminate the ability of the first person on the site to spread salt on a slippery sidewalk. It does nothing to hamper that or diminish that or take that away. It also does not eliminate the right of anyone who's injured in a situation with salt to bring a case. So this doesn't change that at all. It's a very high burden to bring a slip or fall case as it relates to ice accumulation for a lot of reasons, including Minnesota recognizing in Chapter 604 the assumption of risk. We assume the risk of our activity, and we assume the risk in Minnesota of walking on slippery streets. We also recognize in Minnesota law the open and obvious defense for people who are entering onto your property, for dangers that are open and obvious, you don't have liability. They're expected to know that in most circumstances. So there are very few of these cases, but they're based on negligence, as this bill is. And if a case were to come forward and a certified salt applicator was involved in that case, they would be able to say, we followed best management practices. And that becomes an element for them as they defend themselves, and that's what we think is appropriate. But we're not taking anything away, we're not, this doesn't remove anyone's opportunity to put salt or sand down on their property. It just gives training and education to people so that they don't overutilize the product, because we know, and I work with watershed districts and a lot of different clients. We know once that chlorine's in the water, you're not getting it out. And so when it's in Big Cormorant Lake, Senator, where you and I are familiar with, you can't get it out of there. So the less of it we use, the better.
And so, Mr. Chair and
Senator
Mr.
Western.
Carlson or Senator Ruud, right now, maybe we don't eliminate salt. There is higher cost products. I've heard some of that are made out of ethanol, other things, but sometimes they're not used because they're twice the price or higher. But what would stop the department from 10 years from now saying, no more salt use and you must use this, otherwise you're not meeting best management practices?
Senator,
Mr. Carl,
Mr. Chair
Senator
and Senator
Ruud.
Westrom, this is a voluntary program. This is a voluntary certification. No one's making anyone do anything. This simply says that we want to educate people on salt. There is no mandate in this bill anywhere.
Okay. Last question, Mr. Chair, Senator
Senator
Ruud.
Westrom.
What is the department saying it's going to take to implement this, an additional staff time? Or is there any additional staff that's going to be needed, or how do they implement this otherwise?
Senator Ruud.
Mr. Chair and Senator Westrom, well, the bill clearly defines that on 2.10, what's happening, and this program already exists. This is simply letting it go forward because we had a grant to do it before, and the grant has expired, and so this allows the MPCA to go forward with this program.
So, Mr. Chair, Senator Ruud, so
Western.
currently it's been started as a temporary grant program. There will be dollars, which we don't cover in this committee, but are you carrying dollars then for it somewhere else? And what will it take for staff time to implement this program if it's funded by a grant currently?
Senator Ruud.
Mr. Chair and Senator Westrom, there is no fiscal note for this bill.
So there's,
Senator Westrom.
Mr. Chair, Senator Ruud, your understanding is they're saying it won't take any additional staff to do this.
Senator
Mr.
Ruud.
Chair and Senator Westrom, there is no fiscal note for this bill.
Okay, thank you.
Senator Carlson.
Thank you, Mr. Chair. I have almost more comment than question, but the use of road salt has been a particular irritation of mine. What we're looking at here is trying to limit the contamination, and that is a very strong supporter of this bill. Then we're looking at just overuse. And then another thing looks like it's liability. And I'm wondering, in this training, and now, Mr. Carlson, you have taken the training. Can you tell me the difference between calcium chloride, sodium chloride, and magnesium chloride?
Yeah, Mr. Carlson.
Well, Mr. Chairman and Senator Carlson, it was a pass-fail test. They did talk about the different types of de-icers during the training, to be honest with you. And I just want to make sure that we're clear about what this bill does and doesn't do. Because you mentioned it, and Senator Westrom mentioned it, on line 1.14, this does not include any state municipal or other governmental entity. This does not apply to road salt and, these are people that are putting it on basically private property, and we want them to be trained on how much to use. That's really, when you boil it down, that's what it's about.
And thank you, Mr. Chair, and
Senator Carlson.
Mr. Carlson. And this applies on both, personal use on your sidewalks and on the roads. And the roads, we're using so much of it that we also need to deal with that. But when we talk about overuse, when we're talking about what salt to use, there's a massive difference between sodium chloride and calcium chloride. And on the handout here, I see it says that de-icing salt is only effective at certain temperatures if the pavement is cooler than 15 degrees Fahrenheit. And that's true, but it's true for sodium chloride, not calcium chloride. You can take that same statement and put in minus 25, now you're talking about calcium chloride. And now that you know that that is the situation, if somebody who has passed this and gets certified, but they used sodium chloride when it was 0 degrees, 10 degrees, is that best practice? And does that leave them open to liability? Because that is something that's printed right on the bag when you go to Home Depot to buy those 3 products, calcium, magnesium, and sodium chloride. And, if we're talking about overuse and contamination, we need to also, I think, mention that when you buy water softener salt, you're buying sodium chloride. You can't use any other chloride in your water softener. And the solution that comes out of your water softener is now calcium chloride. So you put in sodium chloride. You put in sodium chloride and it comes out calcium chloride because it's taking the calcium out of the water and substituting the sodium in those ions. So there is a lot of additional teaching, use, and other education that needs to be done. And for Senator Westrom, he ought to know that when you talk about fluid in your tractor tires, you're talking about calcium chloride. Because if you put sodium chloride in your tractor tires for traction, it would freeze up when it got cold. It would turn into a solid, whereas calcium chloride does not. So it's a very subtle difference, but it is a very important difference. And on roads, I'm always upset in the early winter when they use sodium chloride and it makes those bumps on the freeways. And also, what we used to say was black ice is not exhaust. It's the use of sodium chloride, and it's the refreezing when it goes below 15 degrees, or roughly 15 degrees. So we need to make sure that the people that are using salt use the right kind, the right amounts, not too much. But if you're going to be using sodium chloride, like a lot of people do, they take their Morton sodium chloride that they use that's table salt, and put it on their sidewalk, it really doesn't do a whole lot. Because calcium chloride has what's called a heat of dissolution, meaning that as soon as it gets wet, it gets hot, and it melts the ice. So this should be part of that certification, that you use the right salt at the right time at the right temperature. Thank you.
And it is.
Mr. Chair, can I nominate Senator Carlson to be one of the people putting together the program here? I think we all learned a little bit today.
I was about to say that we might have one too many Carlsons in the room.
Mr. Chair.
And Mr. Chair,
Senator Ruud.
I would welcome Senator Carlson to go take the certification. It's online, and then you can see for yourself if it's being properly taught. So, and then you could make suggestions if you don't think so. But it's online, and you can get a certificate too.
Mr. Chair, I already have my score.
Senator Carlson.
Mr.
Senator
Chair.
Bigham.
With that chemistry lesson in a civil law committee, we will get Senator Ruud on her way. I would move that Senate File 2768 be recommended to pass and be moved to finance.
Senator Bigham, I have a question or two
Oh.
myself.
Okay, then I can
Could we
withdraw
hold
my
that
motion for a
motion?
second.
Senator Ruud, perhaps Mr. Carlson might be able to answer this. When I look at page 2, line 13, it talks about the liability portion. And it refers to a certified commercial applicator or an owner is not liable for damages if they follow these best practices.
Yes.
So an owner would not be liable if he follows that, despite the fact that he's not an applicator, or he doesn't have a applicator license? Is that how you define this,
Whenever you're ready.
Mr. Carlson?
Thank you, Mr. Chairman. This was a major point in our discussions about this bill, is should the building owner who hires a certified applicator get to use this protection because they've hired someone to do it right? And so, yes, this does protect the building owner, we think at an appropriate level. But yes, you are reading that absolutely correctly. The owner would be, who has hired a certified applicator and used it, would be included in this bill, and that is defined as well. An owner is defined back on 1.17.
The question I have is, there's a lot of people that are landlords of small rental properties, maybe a duplex, a single-family home, maybe even a fourplex somewhere. That's their little business. They don't hire anyone to mow the lawn, they do it themselves. If an owner follows these standards, will he be free of liability if he follows the same standards as an applicator who has a certified commercial license? Or are they in a different standard? Mr. Carlson?
Mr. Chairman and members, unless they had the certification, this wouldn't apply. But those other defenses that we talked about, assumption of risk and open and obvious hazards, and those things all apply to them.
How much does the process take to get a salt applicator license?
I know I drove down to Shakopee, I think it was, and it took me the better part of a day of in-person training. I think you can condense it now and do it in about 4 hours online. They do, they give you the thermal temperature, they tell you how to, monitor the temperature of the ground before you put the product down. And I was glad I did it. I thought I learned a lot from it.
Yeah. So, Mr. Carlson, if one was a small landlord, or a landlord who owned a small property, it might behoove him to get an applicator license so that he could show that he's applying salt under a certified standard. And then he would be able to fall under this liability-free zone if he applies it according to the best practices. Am I reading that correctly?
Absolutely correct, Mr. Chairman.
Okay. Senator Bigham renews her motion.
I do.
Senator
Renew-
Bigham,
I move that Senate File 2768 be recommended to pass and sent to the Committee on Finance.
hearing no further discussion, all those in
Mr.
favor
Chair?
say aye. Oh,
Just,
Sarah
if
Western.
there's no expense to this or fiscal note, I'm wondering why it's going to finance.
Mr. Chair, or, I think I'd like to, Senator Western, you bring up a good point.
But
Despite
unless
the
they've
fact
asked for
that
it,
it's
I-
in the middle of a motion, I think Mr. Turner had some advice on the finance perspective.
Okay.
Sorry, Senator Bigham, let's hear what has to say, and then I'll come back to you. Mr. Turner.
Mr. Chairman and members, there is a fiscal note to this bill. There is no general fund cost to it. There's an environmental fund cost, and according to the note, there's $200,000 a year in staffing at MPCA, $200,000 a year for, or $200,000 the first year for a database, and then approximately $60,000 a year in training costs. But that's offset by $105,000 in revenue that will be made because the trainees will pay for the cost of the class. So it's a net cost to the Environment Fund of $355,000 the first year, and then $175,000 ongoing costs to the Environmental Fund, no general fund cost.
All right. Sir Westrom?
No, Mr. Chair, that's insightful. different than I think I thought earlier.
Thank you. Senator Bigham renews her motion that Senate File 2768 be recommended to pass and be sent to the Finance Committee. Hearing no further discussion, all those in favor say aye. Opposed? The motion prevails. We'll now move on to Senator Ingebrigtsen.
Thank you, Mr. Chair and
Senate
committee.
File 3492. Thank you. We need staff to pick up the spoons. Is Senator Ingebrigtsen in the room?
I am, Mr. Chair.
You're online, all right.
I never leave that room, Mr. Chair.
You should get out once in a while, Senator.
After that enlightening conversation and very electronically, Senator Carlson was quite electrifying there for a minute. I'm not sure what was going on or what he had in his pocket, but it was interesting.
We could give you his phone number and you can continue the discussion.
I think so. I have that. I have that and I will, Senator. Thank you, Mr. Chair. Senate File 3492, Mr. Chair and members, is brought forward by the Department of Health and Human Services. And I will ask Christy Grom, who's present also online, to later explain what this is about. But just real quickly, Senate File 3492 establishes a systemic critical incident review team to review critical incidents related to maltreatment of vulnerable adults and classifies review team data and as confidential data and protected, non-protected data. I could go through the summary if you would like, Mr. Chair, but basically working together with, and I appreciate and want to thank Ms. Primo for working together with Mr. Neumeister with his concerns and with Senator Anderson, who also has an additional 2 words to this bill. I would offer the amendment, if I could, Mr. Chair, would actually bring the bill in order, the A1 amendment, and then I would ask Ms. Grom to go ahead and explain it.
Senator Johnson moves the A1 amendment.
So moved.
It's an author's amendment. All those in favor say aye.
Aye.
Opposed? The motion, or the amendment is adopted. Senator Ingebrigtsen.
Thank you, Mr. Chair and members. And I think with that, I will ask either Ms. Primo maybe to explain the technical part of this amendment. It did happen kind of on the fly here, just within the last day or so. If she could maybe describe the amendment, and then the bill can be talked about from Ms. Grom.
Ms. Priya.
Mr. Chair and members, I'll identify the technical amendment that's within a lot of different policy provisions in the A1 amendment. So if you'll notice, the underlying bill at Section 2 deletes a lot of language from a statute governing certain trusts, but leaves in place a public policy statement. So it was my recommendation that we repeal that whole statute. And in response to that, DHS wanted to retain the policy statement, and it's being moved. If you look at the amendment at line 1.22, there's a new section 2 being added, and it adds essentially that policy statement to a DHS statute that governs medical assistance qualifying trusts. And then you'll look at the very end of the amendment, and Section 4 repeals 501C.1206, which, if you look at the summary, there was a 2021 Minnesota appellate court case that found that federal law preempted this statute. So it essentially does not have the effect of law. And then I will let the stakeholders go through the other substantive provisions of the bill. Some were proposed by McCogy and some were proposed by DHS.
Further discussion? Senator Ingebrigtsen?
Mr. Chair, Ms. Christy Brown from HHS, please, if I could. I know she's online.
Ms. Brown?
Thank you, Mr. Chair. For the record, Christy Graham with the Department of Human Services. Mr. Chair, would you like me to describe the additional elements of the amendment at this time or walk into the bill?
Yes.
All right, so as council had noted, we worked with MinCoG for the most part to get compromise on this language, as well as Mr. Neumeister. So the changes in this amendment essentially are adding language related to data being confidential. There's a sentence that's stricken in the beginning of, I believe, paragraph D that was thought to be too broad and potentially implicating constitutional First Amendment rights. We've also added some reporting requirements at the request of MinCoG so that the critical incident review team would prepare an annual public report and include number of cases that are reviewed in each of these critical incidents each year, a summary of the report, and then some of the conclusions and activities taken that took place as part of each incident. And then as well as recommendations made to make our home and community-based services system safer. And I think that is the basic summary of the amendment, Mr. Chair.
Thank you. Any other questions? I have a question myself. Going to the A1 amendment, starting on lines 123 to 127, it talks about trust instruments. On lines 21, 25, page 1, line 25, it states, before turning to Minnesota Health Care Program funds, and that trust instruments should not be permitted to shield available resources of an individual or an individual spouse. Could someone explain to me what you're doing with that language?
Mr. Chair, if I,
Ms. Brown? Ms. Brown?
yeah, Mr. Chair, I was going to actually defer to my colleague, Ms. Bobs, who is
All right.
more expert on this part of the bill than I am.
All right. Is she available on our,
Mr. Chair.
yeah, could you identify yourself for the record and then proceed?
Yes, thank you, Mr. Chair. For the record, Ann Box, I'm with the Department of Human Services. So this is a policy statement that is in law related to trust. Medical assistance is meant to be the payer of last resort. And this policy statement aligns with federal law about not being able to shield available assets. And that federal law is at 42 USC 1396P, which states that available assets are counted. So because the Court of Appeals decision did not preempt this section of the statute, we are proposing moving it into the medical assistance statutes regarding trust.
Does that recognize the 5-year clawback that the federal government has, or are you superseding that?
Mr. Chair, thank you for the question. It should not supersede that, but I would need to confirm that with policy staff.
Ms. Primo, are you aware of whether or not that the language in this bill would supersede the 5-year clawback in the USC code that they're referring to?
Mr. Chair and members, unfortunately, I don't have the knowledge on the underlying issue, like the 5-year clawback. But I will say that the public policy statement is specifically limited to this statute, which was not preempted by federal law. And the public policy statement doesn't necessarily have any substantive effect. It's taken from the bill in current law at lines 3.23 to 3.26 and just moved over there. So I don't believe it would have any substantive effect. If there's a current practice right now, it's not going to change that.
All right. Senator Anderson.
Thank you, Mr. Chair. Regarding that same area on line 1.25 to the testifiers, how does this address an irrevocable trust fund for an individual who is special needs or disabled?
Ms. Bobst, do you have any suggestions?
Thank you, Mr. Chair. Senator Anderson. This should not affect that. My understanding is that in this case, the federal law is what will be used to evaluate whether a trust is revocable or irrevocable. And I would need to confirm with policy staff how that specifically relates to special needs trust. I believe that is a different section of statute.
So, Ms. Bott.
Senator Anderson.
Thank you, Mr. Chair. So what's the purpose for putting this language in this amendment?
Ms. Bobst.
Thank you, Mr. Chair. Senator Anderson, we would like to, because that language was not preempted in the court ruling, the language that's being repealed is what was preempted. This is just a policy statement. We believe it's still good policy and believe it makes more sense in the medical assistance trust statutes, being that the rest of this section has been preempted by the court ruling.
Mr. Chair.
Senator Anderson.
Ms. Bobst, I have a daughter who has an irrevocable trust fund at this point, and even though it seems harmless in the way it's been written, it seems like it could have an effect on her financial for future purposes.
Ms. Bobst.
Thank you, Mr. Chair. Senator Anderson, I did confirm with my policy staff that this does not have any impact on special needs or pooled trusts, which are trusts for beneficiaries with disabilities.
Thank you.
Ms. Bobst, you made reference in your oral testimony that you're relying on a U.S. federal law. Is there any reference? I don't see a reference in this new language to that specific code. I'm going to ask counsel, is there any reference? I see a reference to U.S. code on page 222.26, but I don't know if that would be the appropriate code. There's also some references to Supreme Court decisions up on 2.6 and 2.7, but I'm not sure if that's the appropriate code, and is it necessary to put it in with the new language? Ms. Primo?
Mr. Chair and members, unfortunately, I'm really not too intimately familiar with this statute because it's generally have been a DHS statute. And so I'm not sure which would be the appropriate legal references. But nothing in the underlying statute in terms of how the recovery process would work is being amended here.
Ms. Bobst, I'm fishing here a little bit, but I'm not sure. You made reference to the U.S. code, but it's not in the written form of law, so, or the proposal before us. Do you have a reference that you're relying on?
Mr. Chair, it's not in the language specifically being moved over. However, it is further down, as you noted, in that statute currently in 256B.056 subdivision 3B. It does reference on line 2.12 and 2.13 the United States Code Title 42, Section 1396P.
Okay.
And Mr. Chair, if I might.
Yes, Senator Ingebrigtsen.
Mr. Chair, with regards to the overview, it does say in response to the 2021 Minnesota Court of Appeals decision, Draheim versus, I believe, Commerce of Minnesota Department of Human Services, and it has another chapter, A20-1300 Minnesota CT application July 12th, 2021, that held the federal law preempts section 501C.1206. This bill repeals the state statute governing the revocability of certain irrevocable trusts. My goodness, that's hard to say. So what I'm gathering here, and that came from staff, that I think where you're going with this is I don't think it applies. I think what's written in the original bill applies, and if it were to be moved anywhere, it would show on the amendment if it needed to be. So, that doesn't, it sounds like a real uneducated guess, but that would be my guess in saying that that's also on the overview. You see that in front of you. I think you have an overview there. Is that something that you're looking for?
I'm just looking for clarity, Senator. I know that this bill will go to another stop if it passes out of this committee. It's going to the HSR committee. That would not be their jurisdiction to make reference to a U.S. code, however. Any members have any suggestions? Is this something that's vital to put into the new language? Nobody knows. All right. Well, why don't we proceed with other testifiers if there are any? Mr. Neumeister?
Chair Limmer, members of the committee, good afternoon. My name is Rich Neumeister. I'd like to thank all the parties, Senator Ingebrigtsen, other staff who have worked on this bill on both sides. And the bottom line, if you look at the bill, and if you look on the language on a line of the bill, lines 225 through 230, and then on 3.1, the DHS is going to be doing critical review of incidents of vulnerable adults in those categories. The language, as it was introduced, mirrored other kinds of critical review incident teams where a lot of information is not available to the public in non-identifiable ways of what do they do? What do they recommend for changes for the system? All those kinds of things. We have heard of year after year abuse in the vulnerable adult area. I applaud DHS of wanting to take an overview of their system. But as the bill was introduced, it would be very hard to know what decisions they made, what recommendations they are going to do or whatever. And that's where that language is in the new amendment, which was adopted in the House, pages in the amendment line 1 through 10 through 1 through 20. So we, the public, and you as policymakers can get some ideas of what's happening when these reviews. This is 2022. We need a little bit more sunshine. And I thank also Senator Ingebrigtsen for giving some additional language so people will understand, which is being adopted here in the Senate, so the public will know. And one final comment. I just want to say, Senator Ingebrigtsen, Chair Limmer, as you go into the sunset from your legislative retirement, this has been a pleasure to have interacted with you over your service here. I know I've gotten your dander up sometimes, but door's been open, and I've enjoyed our conversations on a number of pieces of legislation, as this will be the last one that I'll be working with you on. Once again, thank you, Senator Ingebrigtsen. And
Thank you so much.
Chair Limmer.
Mr. Neumeister?
Thank you, Mr. Chair.
One moment, Mr. Neumeister. I'm still running for reelection. You may see me back.
Oh,
Public willing. Senator Ingebrigtsen.
Mr. Chair, if I could go back to Christy Grom and maybe she can enlighten a little more clarity to the bill or the amendment.
Ms. Brown.
Mr. Chair, thank you. Yes, if it would be, if you're open to it, I could provide an overview of the Home and Community-Based Services critical incident portion of this bill, or we could just adopt the amendment and then move to that, whatever your preference is.
Why don't you just go ahead?
Okay. So thank you, Mr. Chair. So the portion of this bill related to the home and community-based services critical incident review essentially is establishing authorizing language for what we call the culture of safety program. In a nutshell, this is a critical incident review team that would be established, and this bill essentially establishes the program, makes clear what the roles are and responsibilities of the critical incident review team, and then, as mentioned, does allow for some data privacy protections, as well as protections for people that are participating in these reviews so that they can be encouraged to participate. This is a voluntary review process. The language in the bill requires that the proceedings and the records of the incident reviews remain protected, non-public data, and that the opinions, not the facts, but the opinions shared as part of the critical incident reviews are not subject to discovery or introduction into evidence or in a civil or criminal action arising out of the review. So under the amended language, facts discussed in the reviews would remain permissible in those actions. And because I'm very used to Health and Human Services Committee, and I know not everyone here is, I do want to take a bit of a step back and explain what home and community-based services are. So home and community-based services, we often call them HCBS, it's a kind of person-centered care that's delivered in a home and community-based setting as opposed to an institution like a nursing facility or a facility for persons with intellectual developmental disabilities. So these are programs that really help to address the needs of people with disabilities and functional limitations who need assistance with daily activities like getting dressed and bathing and participating in the community. And they're oftentimes characterized as those services that really help people to remain in their homes or to remain in the least restrictive setting. So this particular critical incident review team, which we call the culture of safety, analyzes incidents using what's called a safety science lens to really enhance accountability and safety by moving away from a blame-based approach towards a more holistic improvement-focused approach that really helps us identify how the system as a whole has contributed to a critical incident. So we are required to, as an agency, required to continue to track and address critical incidents. And we do that through various metrics. We use our licensing reviews and other kinds of interventions to make sure when there is a critical incident that we're intervening appropriately. So this new model doesn't take away from the fact that there are still going to be, maltreatment investigations, licensing actions, maybe even criminal or civil actions arising out of certain incidents. One thing that I think is important for the committee to know is that evidence does tell us that agencies and workplaces that use kind of those reactionary approaches might be actually less safe because they don't account for how the system operates and what those systemic improvements are that are needed to make the system safer. So some background on when DHS started this particular project. In 2018, we formed a steering committee to develop a pilot for this critical incident review program. So again, not replacing licensing or maltreatment action. So this is a steering committee that's comprised of providers, lead agencies. We've got supervisors from Hennepin County, St. Louis, Blue Earth, Dakota, Olmsted, Clay, Polk, and Otter Tail at the moment, and then representation from the agency. And right now what we're doing with this pilot is reviewing critical incidents that occur in 245D licensed settings. So those are what you would think of as sort of a group home, a 4-person group home. We call them community residential services. And we're looking at things like medication errors, staff that might fall asleep, wheelchair safety, service terminations, things of that nature. So this establishing language is really going to help us transition to that next phase and improving safety and accountability for the system. So we've got that oversight in statute and protections in place so that we can encourage people to participate. And that's the basic overview of that particular provision of the bill. I know that Senator Anderson has a provision as well related to best interest of the child and family law statute, adding the term developmental disability. I think that's a pretty straightforward change in the amendment. I didn't mention that earlier. I apologize. But I will stand for questions that members might have. And I also have experts with me to weigh in if I can't answer questions.
Any questions? Is there any other discussion regarding this bill? Is there anyone in the audience who wishes to speak for or against the bill? Senator Bigham?
Mr. Chair, if there's no further comment, Senator Ingebrigtsen needs somebody to move the bill, correct?
Yes.
Okay. I would move that Senate File 3492 as amended be referred, or be recommended to pass and referred to HSR.
Senator Bigham moves that Senate File 3492 be recommended to pass and move to the HSR committee as amended. All those in favor say aye. Aye. Opposed? The motion carries. Thank you. I will
Thank you,
now-
Mr. Chair,
Thank you, Senator Ingebrigtsen.
Chair members, and thank you for, again, to Mr. Newmeister for his comments on allowing me to be able to carry this legislation with his help, and he's been a great assistance over the years, and I appreciate that. Thank you.
Thank you. We'll now move on to Senator Pratt's bill, House File 3254. Senator Pratt, are you in the room? Going. Oh. Is Senator Draheim in the room?
Senator Platt, Coran's gonna produce.
So what are we doing? We're just going to recess. We'll be standing in recess.
Are you kidding me? Are we gonna recess? Let's do recess. I just filling in for Draheim. Are we gonna recess?
Committee's in recess.
Okay. We know where the boss is.